Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question from, YouTube user Wizzy the Gamer, a very vocal cat attacking my feet. And Wizzy's question is as follows. I have a question. I have an answer. Is my binding arbitration agreement supposed to require a right to sue letter before I file for arbitration? I feel like my arbitration agreement is forcing me to engage in litigation procedures while forbidding litigation at the same time in order to make my life harder. Also, can I be forced into arbitration days after reporting my company to the EEOC? This is ridiculous. Okay. So this is a very complex field of law that I'm going to give you a very uncomplex, loose rule to, but like trust your counsel, talk to your local counsel, get a good idea of the local rules, all those things. Okay? But here we go. I'm gonna give you the loose idea of the lay of the land. So I guess the first question we should address is can an arbitration agreement keep you out of the Equal Employment Opportunity Commission? And the answer is generally no. An arbitration agreement, mandatory, voluntary, involuntary, if you're just going to arbitration, you can choose to go to arbitration and then not filing the EEOC if everybody voluntarily agrees to that. But if you have a mandatory arbitration agreement and it says, hey, you can't go to litigation, you got to go to arbitration, the case law is fairly clear that agreement cannot keep you from filing with the Equal Employment Opportunity Commission. Now, what is the value of a filing with the EEOC? We talk about that extensively on the channel. Sometimes there's some free discovery. There's things you might want to do in the EEOC level that are going to be driven by the specifics of your case. So you may want to do that. Certainly, I have done that before going on to file an arbitration. And I've also, I've seen cases that did it, and I've seen cases that didn't, that went to arbitration. So you might choose to, you might not. The arbitration agreement cannot keep you from filing with the EEOC. The arbitration agreement may be able to keep you from filing litigation. Now, a lot of people will fight that in federal court, and the success rate is going to depend a little bit on, the specifics of your situation and where you are. So, like, a mandatory arbitration agreement is not a sure thing, but it is probably like an 80% of sure thing, right? There's a good chance an arbitration agreement might be enforced by a federal court. They might force you into arbitration. If that's, depending on how your agreement's drafted and how the federal court judge, or state court judge, I guess, will interpret it, like there's a good chance you're going to end up in arbitration. But your question essentially is like, why am I forced to go to the Equal Employment Opportunity Commission and get a right to sue letter if I'm then not allowed by this agreement to file in federal court, which is what I would use that right to sue letter for, right? And your question is entirely valid, and you're not going to like the answer. They're fucking with you. They're just straight up trying to give you more obstacles, more hurdles to jump before you can get your case adjudicated in arbitration. And your point is going to be like, well, I don't even want to go to arbitration. I don't want to be bound by this mandatory arbitration agreement with all these extra hurdles in it. And I hear you, but that's the agreement that you executed. And I understand that it was a contract of adhesion, like you needed a job. This was the requirement for the job. You didn't feel like you could negotiate it, maybe. I'm on board with all of that. There's a reason why I don't like mandatory arbitration agreements. I think arbitration can be fantastic if everybody agrees to it. I think it can be really, really valuable, really efficient, really a sophisticated look at the law. In a variety of ways, I think there are many, many, myriad advantages to arbitration in certain situations for certain plaintiffs. Other situations, it's the last thing you want, right? And so I'm generally against mandatory arbitration clauses. Here, not only do you have mandatory arbitration, but it's giving you additional hurdles. Will that be upheld? Probably. And even if it wasn't, fighting the clauses in your arbitration agreement that require you to jump those hurdles would probably cost more in terms of legal fees and attorney time than jumping those hurdles would be. Like, the EEOC is not such a high hurdle for your employment attorney to handle for you. They can do that, and they can even get some value out of it. So, like, are they going to be thrilled to be doing the extra work? Depends on your case. Depends on the firm. Depends on their strategy of the case. Depends on their approach to litigation. Like, maybe they're thrilled to be in the EEOC. Maybe they're not. Maybe this is a waste of time in their eyes. Maybe they're like, let us do the extra work to add the extra value. I don't know, right? I'm not them. I'm not your counsel. But to answer the core of your question, because you say this is ridiculous. Yes. Yes. The people who drafted that agreement are fucking with you. And they're probably going to get away with it. The good news is, not that big a deal, and you might get something out of it. Good luck. Last note, pay attention to the statutes of limitation in play in your case, because sometimes the EEOC can actually take so long that it will cause you to lose some state and local statutes of limitations. So keep an eye on that. Remember that you can pull your right to sue letter from the EEOC in certain scenarios, and then you'll be able to proceed on your litigation. Don't let it push you out so far. If you have a very overburdened EEOC office or a very lazy EEOC office, it can push you out so far that you lose some of the state and local claims. So just stay on top of that. Or talk to your counsel about that. Far better in terms of options. If this was helpful, like, subscribe, comment down below. It helps our channel to grow. I don't know. Good luck, everybody. I'll be checking the comments down below to see if you have any follow-up. Take care.